In terms of the cost, I think you find that the cost at the other end, if something goes wrong, far exceeds any professional cost they would pay at the outset. We see it time and time again where the people have tried to cut corners and they find that their capital gains tax, for example, on a sale or exit from the business might be double what it otherwise should have been if it was properly structured. In terms of considering exit, we've had circumstances where all of the leases might be held in a separate realty company. And so just in terms of exit, that's a simple process of transferring the shares in that entity that might own 100 leases, for example. So getting the advice up front, I think, is critical. As to the ratio between legal and accounting, it's difficult for me to say what that should be. It depends upon the franchisor's individual circumstances to a large extent. If the franchisor hasn't got sufficient financial resources to do the job properly, there's going to be issues. And there's going to be issues down the track in terms of disputation with franchisees. There needs to be sufficient funding in place to properly do the job, otherwise they shouldn't proceed. Well, the Franchising Code of Conduct is the regulatory regime which operates in the sector, and the most important legal document a franchisor has to produce is the disclosure document. The Franchising Code of Conduct details in quite precise terms what is to be included in that disclosure document, and in broad terms it gives the prospective franchisee, information in respect of the business experience of the franchisor, the history in respect of previous franchisees, and information in relation to, among other things, litigation that the franchisor may have been involved in. I think that, look, it can be a lengthy document. It includes the franchise agreement in the form it's to be executed. So I think you have to be a long way down the track before you start issuing disclosure documents.